Imagine a Supreme Court ruling so toxic and so fundamentally broken that decades later, a Chief Justice of the United States actually goes out of his way to declare it has absolutely no place in American law. Welcome to this deep dive.
Yeah, thanks for having me. And, today we aren't just looking at a bad legal decision. We are looking at a moment where the United States government actively lied to its own Supreme Court.
Right, which is just mind-blowing. Usually when we talk to you, the listener, about something like a medical diagnosis, there's this expectation of clinical precision.
Exactly, like a broken bone.
Yeah, you break your arm, the x-ray shows that jagged white line, the doctor just points and says, there it is. Broken or not broken.
Very black and white.
Totally. But today, we are taking that concept, that unsettling shift from an illusion of perfect clinical precision to a reality of, well, profound, murky failure, and applying it to the highest court in the United States.
It's a heavy shift. We're really looking at the myth of the Supreme Court as this dispassionate, infallible arbiter of justice,
Like, it's a machine that just reads the Constitution, looks at the facts, and dispenses pure, objective rulings.
Right, which is a deeply comforting myth, honestly. It's much like that clean x-ray.
Yeah, we desperately want to believe that.
So we do. We want to believe that when the stakes are at their absolute highest, when the whole country is panicking, the ultimate legal authority will remain completely unswayed by prejudice or, by the sheer blinding pressure of a historical moment.
Okay, let's unpack this. Our sources for today form a massive, comprehensive dossier on the 1944 Supreme Court case, Korematsu v. United States.
And we aren't just looking at the official court transcripts from 1944.
Right, no, we are looking at the deeply buried evidence. I mean, intelligence reports, internal memos, secret archival documents.
Stuff that literally took 40 years to see the light of day.
Exactly. But before we get into the abstract legal theories, we really have to establish the atmosphere of 1942. Because the Supreme Court's abdication doesn't just happen in a vacuum.
No, not at all. It happens in a society completely gripped by hysteria. That context is vital.
Because if we don't understand those weeks and months right after the attack on Pearl Harbor in December 1941, none of this makes sense.
Right. The subsequent legal gymnastics are baffling without it. The west coast of the United States was consumed by fear of an imminent Japanese invasion.
I mean, there were blackouts, right? And rumors of enemy submarines just sitting off the coast.
Yep. A pervasive, terrifying anxiety. But layered on top of that legitimate wartime panic was a deep historical bedrock of anti-Asian racism.
Which had been there for a long time.
Oh, absolutely. It had existed in California and along the West Coast for decades.
We're talking about a history of exclusionary immigration laws, alien land laws that literally prevented Asian immigrants from owning property.
And intense economic resentment. I mean, white agricultural groups explicitly saw the post-Pearl Harbor panic as a golden opportunity.
Wow, an opportunity to do what?
To eliminate successful Japanese-American farmers who were outcompeting them. The political pressure from these lobbying groups, combined with the military's demands, created a powder keg.
And that powder keg detonated in early 1942, right? Resulting in the mass deprivation of liberty for, 120,000 people of Japanese descent?
Exactly, 120,000. They were systematically removed from their homes, their businesses, and their communities.
And to ground this in the most shocking demographic reality for you listening, 2/3 of those 120,000 people were United States citizens.
Born in America, holding the exact same constitutional rights on paper as any other citizen.
I think we really need to linger on what that actually looked like for a real family. We hear words like internment or evacuation, and those bureaucratic terms just sanitize the violence of it.
They absolutely do. It sounds orderly, but it wasn't.
Families were given a matter of days to pack whatever they could carry in a single suitcase. They had to sell off thriving businesses for absolute pennies on the dollar.
Abandoning farms they had worked for generations, and, where did they go? They weren't immediately sent to those remote desert camps we always picture.
If they weren't, where did they go first?
Well, the logistics of moving 120,000 people meant they were first funneled into what the government called assembly centers.
Which were what exactly?
These were often racetracks or fairgrounds. The Tan Fern racetrack near San Francisco is a notorious example.
A racetrack, so they were sleeping in.
In literal horse stalls.
Mm-hmm.
Families, American citizens, were forced to live in horse stalls where the smell of manure was still fresh.
Oh my God.
Yeah, the walls were just hastily whitewashed. There was zero privacy, inadequate plumbing, and armed guards and watchtowers looking down on them.
Calmly and factually, this was a mass race-based incarceration. There's no other word for it.
None. And that brings us to the human face of this constitutional crisis.
Right.
Fred Korematsu.
Right. Who was he? Because he ends up at the very center of this legal storm.
Well, Fred Korematsu was not an activist. He wasn't out looking for a fight with the government. He was a 23-year-old welder from Oakland, California.
Just a normal guy.
A normal U.S. citizen. In fact, he had actually tried to enlist in the U.S. military to fight for his country against the Axis powers.
Oh, wow. Why didn't he serve?
He was rejected because of stomach ulcers, so he just had a life, a job, and a girlfriend, Ida Boitano, who happened to be Italian-American.
And when the military orders came down requiring all persons of Japanese ancestry to report to those assembly centers, Fred made a very personal, human decision.
Yeah, he didn't plot a rebellion or commit any act of sabotage. He just wanted to stay in his home state with the woman he loved.
And he went to pretty extraordinary lengths to do that, right?
He really did. He changed his name to Clyde Sarah. He claimed to be of Spanish and Hawaiian descent so people wouldn't question him.
Didn't even get surgery.
Yes. He underwent a minor, painful plastic surgery procedure on his eyelids to alter his appearance. He was just desperately hoping he could blend in and avoid the camps.
But it didn't work. On a street corner in San Leandro in May of 1942, he was recognized, arrested, and thrown into a local jail.
From there, the ACLU gets involved. A guy named Ernest Bessig visits him in jail, and Fred agrees to let his case be the ultimate test case.
And that arrest sets the stage for a legal battle that forces the Supreme Court to answer a fundamental question about the very nature of American democracy.
The biggest question imaginable.
Right. When the executive branch, backed by the military, looks at the courts during a time of ultimate crisis and says, "Trust us, we have to do this," is a court that simply salutes and steps aside, still functioning as a court.
Or is it just a rubber stamp with a gavel? That is the core mission of our deep dive today.
Exactly. We are going to take the Supreme Court majority's stated logic seriously. We are going to examine the blistering dissents that saw right through the facade.
And then we're going to uncover the suppressed intelligence hidden in the archives.
Evidence that fundamentally changed the legacy of this ruling forever. So, to understand how the Supreme Court failed so spectacularly, we first have to understand exactly what the military demanded.
And how the court's majority completely contorted itself to approve it. So let's step back to February 1942. President Franklin D. Roosevelt signs Executive Order 9066.
Now, reading the text of this order, it's actually chilling because of what it doesn't say. I mean, it never explicitly mentions Japanese Americans, does it?
It doesn't. It is a masterpiece of sterile bureaucratic language. Executive Order 9066 simply authorizes the Secretary of War and the military commanders he designates to prescribe military areas
from which any or all persons may be excluded. It sounds like a generic zoning ordinance.
It does, but in practice, it paved the way for the military to designate essentially the entire west coast of the United States as an exclusion zone.
And the man given the power to draw those lines and decide who actually got excluded was General John L. DeWitt.
Right, the head of the Western Defense Command. General DeWitt is the architect of the physical orders targeting people of Japanese descent.
But if you're going to violate the civil liberties of 120,000 people, you need a justification. And DeWitt provided his rationale in what was called his final report.
And the final report is a genuinely astonishing document. General DeWitt claimed that the military faced a dire existential threat of espionage and sabotage from the Japanese American population.
He argued there was a massive fifth column operating on the West Coast. Let's define fifth column for you listening, because that's a crucial term from that era.
Certainly. A fifth column refers to a group of people within a country who are secretly sympathizing with and assisting the enemy.
So like through sabotage or espionage?
Exactly. Subversion from within. DeWitt was claiming that the Japanese American community was actively working with the Japanese Empire to prepare for an invasion of California.
But his proof for this massive, organized fifth column is where the logic just completely falls off a cliff into madness.
It really does.
General DeWitt literally claimed that the very absence of sabotage by Japanese Americans on the West Coast was proof that a massive, coordinated plot was imminent.
I know. It is a terrifying, closed loop of circular logic. He argued, effectively, that because there had been no fifth column activity, no blown-up train tracks, no poisoned water supplies, it meant they were highly organized.
Like they were disciplined and just waiting for a signal from Tokyo to strike all at once.
Wait, how did the lower courts not throw that out immediately?
Because of the context of war.
But If a local police chief used that logic today, like, Your Honor, this neighborhood hasn't had a single robbery in a year, which proves they are a massive organized crime syndicate waiting for the perfect heist, he'd be laughed out of the courtroom.
Oh, absolutely. He'd be fired. But this was under the intoxicating power of military necessity during wartime. DeWitt's logic creates a scenario where you cannot possibly defend yourself.
Right, if you commit sabotage, you're an enemy. If you are perfectly peaceful and patriotic, you are even more dangerous because you're hiding it.
Exactly. It strips away the presumption of innocence entirely and replaces it with the presumption of inherited biological guilt.
He didn't even try to hide, did he? No, DeWitt was famously quoted as saying, "A Jap's a Jap. It makes no difference whether he is an American citizen or not." The racial animus wasn't hidden. It was the entire foundation of his military assessment.
And this translates into physical orders placed on Fred Korematsu that create this completely rigged maze. If you look at the mechanics of what was demanded of him, it's just Kafkaesque.
It's totally contradictory.
Fred gets an order from the Military Public Proclamation Number 4, which institutes a curfew, and says it is a crime for anyone of Japanese descent to leave the designated military zone.
Right, so he is forbidden from packing up his car and moving to Nevada or Colorado. He is frozen in place by the military.
But at the exact same time, he is subject to Civilian Exclusion Order Number 34, which makes it a federal crime for him to stay in the military zone where his house is.
You cannot leave. You cannot stay.
The only legal move you have left is to surrender yourself to civil control, which meant walking into an assembly center to be shipped off to a concentration camp.
The government criminalized his very existence in his own hometown.
How could any rational legal mind look at this conflicting set of orders and say, this wasn't a case about forced detention?
What's fascinating here is exactly who wrote the majority opinion for the Supreme Court that somehow justified this rigged maze.
Right.
It was Justice Hugo L. Black. And if you study American legal history, Justice Black is a towering figure. This is where the historical paradox just screams at you.
Let's explore that paradox, because Hugo Black is not some cartoon villain conservative pushing for a police gate. He's one of the most complex figures of the 20th century court.
Profoundly complex. I mean, he had a dark past. He had briefly been a member of the Ku Klux Klan as a young politician in Alabama.
Which is shocking enough on its own.
It is, but by the time he was appointed to the Supreme Court by Franklin Roosevelt, he had become a staunch New Deal liberal.
And throughout his long tenure, he evolved into an absolutist on civil liberties, right?
Yes. He was a massive champion of the First Amendment, arguing that no law means absolutely no law restricting speech. He fought for strong criminal protections for defendants.
He's the guy you would normally expect to be the absolute fiercest defender of a lone citizen facing the crushing weight of government overreach.
Precisely. He viewed the Bill of Rights as a sacred text. And yet, this champion of civil liberties authors one of the most oppressive, catastrophic decisions in United States history.
How does he do it? How does he sleep at night?
Well, the legal sleight of hand he pulls off in the Korematsu decision is dizzying. Because he doesn't just say, the military can do whatever it wants.
Right, he starts the opinion by announcing a principle that sounds incredibly noble. He essentially invents a foundational rule for modern civil rights law right in the middle of this terrible ruling.
Yes. Justice Black lays down a constitutional marker. He writes that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect.
That phrase is monumental.
It is, and he says that courts must subject such racial classifications to the most rigid scrutiny. He explicitly states that pressing public necessity may sometimes justify the existence of such restrictions, but racial antagonism never can.
For you listening who might not be steeped in constitutional law, we need to clarify what rigid scrutiny, which we now call strict scrutiny, actually means.
It's the highest bar in the law.
Right. In the legal world, strict scrutiny is usually a death knell for a government policy. When a court applies strict scrutiny, the government almost always loses.
The government has to prove they have a compelling state interest and that their policy is narrowly tailored.
Meaning it's the absolute least restrictive way to achieve their goal.
It is the highest, most unforgiving bar in constitutional law. So if you are reading Black's opinion in 1944 or reading it today, you hit that opening paragraph and think, okay, rigid scrutiny.
The court is going to hold the military's feet to the fire.
Exactly. You think they're going to demand rock-solid, irrefutable proof from General DeWitt that stripping 120,000 citizens of their rights is an absolute, unavoidable public necessity.
But that is exactly the sleight of hand. He announces this incredibly demanding test, and then he just completely walks away from it.
He absolutely abdicates the responsibility to apply the test he just invented.
He essentially says, we must use the most rigid scrutiny. Okay, we've scrutinized it, and the military says there's a necessity. We are at war. The military authorities know best.
And he adds, therefore, we cannot reject their judgment as unfounded. He doesn't ask for evidence. He doesn't check the general's homework at all.
He just takes DeWitt's word for it. So rigid scrutiny just meant the Supreme Court asking the military, are you sure?
And the military saying, yep, we're sure.
And the court saying, good enough for us.
Yeah.
It's not scrutiny at all. It's blind deference dressed up in fancy legal jargon.
That is precisely what it meant in practice. The court completely refused to investigate the underlying facts. They refused to demand evidence of this supposed fifth column.
They effectively ruled that in wartime, the military's assessment of threat is beyond the reach of the judicial branch's fact-checking.
And to make this incredibly bitter pill easier to swallow, Justice Black insisted on framing the entire case through a microscopic pinhole.
The pinhole framing. I mean, he kept insisting over and over that Korematsu was just an exclusion case.
Yes. He deliberately isolated the single order, the order making it illegal for Fred to stay in San Leandro. Black wrote that Korematsu was simply being excluded from a military area.
As if the military was just asking him to politely step outside a fenced-off base, he completely ignored the destination.
Right, he wrote as if Fred could just go rent an apartment in Chicago. He ignored the undeniable reality of the assembly centers, the barbed wire, and the desolate incarceration camps in the desert.
He severed the order to leave from the reality of where they were being forced to go.
The majority opinion tried desperately to compartmentalize the atrocity. They tried to dress extreme deference up as measured constitutional law to make it legally palatable.
But they didn't fool everyone. 3 justices on that court saw exactly what was happening. They refused to go along.
And their dissents didn't just disagree with Justice Black's logic. They issued dire, prophetic warnings for the future of the Republic itself.
Let's really dig into those dissents, because this is where the true intellectual and moral battle of Korematsu happens. The majority opinion is 6 justices.
And the dissenters are 3. Justice Owen Roberts, Justice Frank Murphy, and Justice Robert Jackson.
And they systematically, ruthlessly dismantle Justice Black's fantasy. Let's start with Justice Owen Roberts.
Justice Roberts went straight for the structural absurdity of those military orders we discussed earlier, the rigged maze. He completely rejected Black's pinhole framing.
He refused to treat this as a minor inconvenience about a curfew or a simple exclusion. He essentially says, I'm not going to pretend I don't see the barbed wire.
Exactly. Roberts laid out the stark reality of the conflicting orders. He famously labeled the paired orders a cleverly devised trap.
Which is such a perfect description.
It is. He wrote that you cannot look at an order forbidding a man to leave his home and an order making it a crime to stay in his home as anything other than a singular mechanism.
A mechanism designed solely to force him into federal custody. He cuts right through the legal fiction.
He states the plain truth. Fred Korematsu wasn't being convicted for a minor zoning violation. He was being convicted for refusing to submit to imprisonment based entirely on his ancestry.
Roberts exposes the mechanics of the trap. But it was Justice Frank Murphy who exposed the dark, rotting soul of the orders.
Frank Murphy's dissent is one of those rare documents in Supreme Court history that gives you chills when you read it.
He was a deeply principled man, and he did not hold back.
Not at all. He uses a phrase that has echoed through history, branding the majority's decision the legalization of racism.
The legalization of racism. It's a devastating phrase, because Murphy looks at the fundamental assumption of the military that individuals of Japanese descent are inherently disloyal, that treachery is in their blood, and he realizes what the United States is becoming.
If we connect this to the bigger picture, Murphy explicitly drew the parallel that everyone else was too afraid to make.
Because we were in the middle of World War II.
Exactly. Murphy writes that assuming a whole race of people is disloyal by birth is the exact same abhorrent, un-American reasoning used by the dictatorial, fascist tyrannies the United States was currently sacrificing blood and treasure to destroy.
He essentially accuses the military and his fellow justices of adopting the ideological weapons of Nazi Germany and Imperial Japan.
It was a brutal comparison, but an accurate one.
And here is where I want to push back on Justice Black's logic.
Yeah.
Given that only people of Japanese ancestry were subjected to mass removal, I mean, German Americans and Italian Americans on the West Coast were absolutely not subjected to mass, indiscriminate incarceration. How on earth could the majority pretend this wasn't about racial hostility?
Well, Black tried to argue it was purely about geography and proximity to the Pacific Theater.
Right, combined with the specific nature of the threat from the Japanese Empire.
He claimed it was a military judgment about vulnerable coastlines, not racial prejudice. But Murphy tore down that military necessity facade piece by piece.
He pointed out that the military was making sweeping generalizations based on outright misinformation and blatant racial animus.
Yes. Murphy argued that General DeWitt's own report cited things like Japanese Americans attending Japanese language schools or having traditional cultural practices as evidence of disloyalty.
Which is just punishing people for having a culture.
Exactly. Murphy argued that constitutional rights don't just evaporate because a general feels anxious or harbors personal prejudices.
He asserted that the court has a sacred duty to ensure that military claims are based on actual, verifiable evidence, not on racial animus disguised as military strategy.
Which brings us to the third dissenter.
Here's where it gets really interesting. We've got Roberts exposing the mechanical trap. We've got Murphy exposing the blatant racism. But then we have Justice Robert Jackson.
And his dissent, it isn't just aimed at General DeWitt or the military.
His dissent is aimed like a laser right at the heart of the Supreme Court itself. Let's spend some time analyzing this, because Jackson introduced what is now known as the loaded weapon theory.
Jackson's dissent is perhaps the most philosophically profound and, frankly, the most terrifying, because Jackson was looking way beyond 1944.
He is making a very subtle but crucial distinction between a military mistake and a judicial precedent, right?
That distinction is the entire core of his argument. Jackson was a realist. He had served as Attorney General. He understood executive power perfectly.
He knew how the sausage was made.
Right. He acknowledged that in the heat of a brutal war, the military is going to make harsh, immediate, and sometimes unconstitutional decisions. A general's job is to secure the area, and sometimes they will overstep constitutional bounds in the panic of the moment.
Jackson argued that a military error, while terrible, is a passing emergency. The military does something wrong, the war eventually ends, the military order expires, and the specific crisis is over.
The military action is an isolated incident constrained by time. But, Jackson warned, the moment the Supreme Court takes that unconstitutional military order and writes an opinion rationalizing it, the situation permanently changes.
Because a judicial opinion is not temporary.
Exactly. It does not expire when the peace treaty is signed. It becomes permanent law.
So by blessing the atrocity, the court institutionalizes it. They weave it right into the fabric of American law.
Jackson's exact words are haunting, and they should be read by every law student. He wrote that once the court rationalizes this kind of racial exclusion to justify a military expedient, that principle lies about like a loaded weapon.
Ready for the hand of any authority that can bring forward a plausible claim of an urgent need.
Lies about like a loaded weapon. That metaphor is brilliant and terrifying.
Because what does a loaded weapon do? It sits quietly in a drawer, doesn't do anything on its own, but it waits.
It waits for the next person to pick it up.
World War II ends, the internment camps finally close, the Japanese Americans go home to try and rebuild their shattered lives. But the Supreme Court's ruling that the government has the power to do this remains on the books.
Jackson's prophecy regarding future executive power claims is chillingly accurate. He warned that once you establish the legal framework that military necessity overrides the Constitution without requiring proof, that framework just waits in the shadows.
It waits for the next crisis, the next war, the next terrorist attack, the next pandemic.
And next time the nation feels deeply afraid, and the next time the executive branch feels panicked, they don't have to invent a new rationale for violating civil liberties.
They just pick up the loaded weapon the court left lying around from 1944. They just point to Korematsu and say, see, the court already said we can do this when there's an emergency. And trust us, there is a massive emergency right now.
Jackson recognized that by trying to accommodate the military in this one specific instance, the court was permanently altering the balance of power. They were crippling the judiciary's ability to act as a check on the executive branch forever.
He argued that if the court couldn't strike down the order, they should at least refuse to enforce it, rather than distort the Constitution to approve it.
So we have these three incredibly powerful, articulate dissents. Roberts calling out the trap, Murphy calling out the racism, Jackson prophesying the loaded weapon.
But here is the profound tragedy of this story. They were dissents. They lost.
The vote was 6-3. Justice Black's majority opinion ruled the day. The deference stood. The internment continued.
And the crucial, heartbreaking thing to remember about these dissents is that they were written based on an assumption.
Right. Roberts, Murphy, and Jackson all believed that the military was simply overreacting.
They thought General DeWitt was prejudiced, panicked, and factually wrong in his assessment, but they still operated under the belief that the government genuinely thought there was a threat.
They thought it was a case of tragic, racist incompetence.
Right, they thought the government was making a massive, terrible mistake. But decades later, history revealed something far, far more sinister.
The government hadn't just overreacted. They hadn't just made a mistake.
The executive branch had actively, deliberately, and maliciously deceived the Supreme Court of the United States.
Which brings us to the darkest layer of the entire dossier we are examining today, the suppressed intelligence.
Okay, let's unpack this suppressed evidence. Because when I was reading this part of our sources, my jaw literally dropped. It fundamentally shifts the entire narrative.
It does. It changes everything.
While General DeWitt was running around the West Coast waving his hands about an imminent existential threat from a Japanese-American fifth column, the actual intelligence agencies of the United States government were systematically investigating those exact same claims.
Yes, and their findings were unambiguous. The Office of Naval Intelligence, specifically a man named Lieutenant Commander Kenneth Ringel, conducted an exhaustive investigation into the Japanese-American community.
Now, Ringel wasn't some desk jockey in Washington, was he?
Not at all. He spoke Japanese. He had lived and worked closely within the Japanese-American communities in Southern California and Hawaii. He actually knew the people he was investigating.
Unlike DeWitt, who just sat in his office at the Presidio in San Francisco. And what did Commander Ringel conclude after his exhaustive investigation?
Ringel concluded that the vast, overwhelming majority of Japanese Americans were entirely loyal to the United States. He estimated that at least 90% or more of the community was fully patriotic.
Wow.
He found that the very small number of individuals who might be of concern were already well known to the authorities, were already under surveillance, and could easily be dealt with on an individual, case-by-case basis.
He explicitly concluded there was no mass disloyalty, no organized espionage, and absolutely no factual basis for General DeWitt's claims that mass race-based exclusion was necessary.
But it wasn't just the Navy, was it? The Navy says DeWitt is wrong. Who else investigates?
The FBI, under the direction of J. Edgar Hoover.
And we need to be clear, J. Edgar Hoover was hardly a soft-hearted civil libertarian.
No, definitely not.
Yeah.
But his agents investigated the claims of a fifth column and found absolutely zero evidence to support DeWitt's assertions.
Hoover actually mocked the military's panic in internal communications.
Furthermore, the Federal Communications Commission, the FCC, investigated one of DeWitt's most specific and wild claims. DeWitt claimed that Japanese Americans were using illicit hidden radio transmitters to signal enemy Japanese submarines off the California coast.
A claim that sounds terrifying to a public that doesn't know any better.
But the FCC, the agency whose sole job is to monitor the airwaves, investigated. They brought in sophisticated direction-finding equipment.
And they found that DeWitt's claims were completely fabricated. The signals the military thought were illicit transmissions were actually just interference from their own badly tuned radios or commercial broadcasts.
The FCC concluded the claims were based on sheer incompetence by military radio operators. So let's synthesize this. The Office of Naval Intelligence, the FBI, and the FCC all essentially look at the military's core rationale for throwing 120,000 people into camps and say, this is entirely baseless garbage.
The government's own intelligence apparatus across 3 different agencies knows there is no military necessity.
And here is where the constitutional crisis deepens into a profound, deliberate ethical scandal. As the Korematsu case makes its way to the Supreme Court, lawyers inside the Department of Justice have to write the briefs defending the government's position.
It's their job to defend the internment.
Nice.
And 2 key DOJ lawyers, Edward Ennis and John Burling, start doing their research.
And in the process, they discover this contradictory intelligence. They find the Ringel report. They find the FBI and FCC memos.
They realize that General DeWitt's final report, the specific document the Supreme Court will rely on to justify the internment, the document Justice Black will default to, is full of demonstrable intentional falsehoods.
Ennis and Burling are deeply alarmed, right? They recognize their ethical duty as officers of the court. You cannot lie to the Supreme Court. You cannot present false evidence.
So they draft a crucial footnote to be included in the government's brief to the court.
What did the footnote say?
The original draft of the footnote was designed to explicitly alert the justices that the Justice Department could not vouch for the factual accuracy of General DeWitt's claims regarding espionage and illicit radio transmissions.
It effectively warned the court that the military's primary justification was directly contradicted by the government's own intelligence agencies.
They were trying to throw up a massive red flag.
They were trying to say, hey, Supreme Court justices, before you rubber stamp this massive violation of human rights, you should know that our own spies, our own FBI, say the general's report is fiction.
But that warning never reached the justices. The Solicitor General of the United States at the time was Charles Fahey. It was his responsibility to argue the case before the Supreme Court.
And Fahey was under immense pressure from the War Department, specifically from Assistant Secretary of War John McCloy, to present a unified front. The military did not want the DOJ contradicting them.
So what does Solicitor General Fahey do? Fahey reviews the footnote drafted by Ennis and Burling, and he actively suppresses it.
How exactly did he do it? Does he just delete it?
He does something more insidious. He alters the language so significantly that it completely obscures the warning.
Wow.
Instead of saying the DOJ has evidence contradicting DeWitt, he waters it down to a vague statement that merely says the DOJ relies on the military's judgment, omitting any mention of the FBI, the FCC, or the ONI's findings that DeWitt's facts were wrong.
He deliberately withheld exculpatory intelligence from the Supreme Court. Let's really emphasize the gravity of this for you listening. The highest court in the land made its ruling, a ruling that legally justified the imprisonment of 120,000 American citizens while being fundamentally, intentionally blinded by the executive branch.
The court deferred to military necessity without ever being told that the government's own agencies had concluded no such necessity existed. It is a breathtaking subversion of the judicial process.
Think about that level of betrayal. It's like, imagine a defense attorney finding out 40 years after their client was executed that the lead prosecutor had a DNA lab report proving the client's innocence sitting in their desk drawer the whole time.
And they deliberately hid it from the judge and jury to win the case.
Except this isn't one client. This is 120,000 people. And it's playing out at the absolute highest level of constitutional law.
That analogy is perfectly apt. The suppression of evidence transforms the Korematsu case from a tragic story of judicial weakness and wartime panic into a chilling narrative of calculated government misconduct and fraud upon the court.
But let me ask you this, a massive what-if that just haunts this whole story. We know Justice Black wrote that rigid scrutiny test and then ignored it.
Right.
If Solicitor General Fahey hadn't hidden the evidence, if he had let Ennis and Burling's footnote stand, if the court had actually seen Commander Ringgold's report and Hoover's memos in 1944, would Justice Black's rigid scrutiny test have forced a different outcome?
Or were the justices so blinded by the hysteria of World War II that they would have found a way to rubber stamp the camps anyway?
Yeah, that's the million-dollar question.
This raises an important question, and it's one that legal historians fiercely debate. On one hand, a cynic could argue that the justices were desperately looking for a way out. They did not want to second-guess the military in the middle of a two-front world war.
Even if they had seen the conflicting intelligence, they might have said, well, the military and the Navy disagree. We aren't military experts. We must defer to the general on the ground.
They could have just thrown up their hands and said, not our problem, we defer. Exactly. But on the other hand, look at the architecture of the majority opinion.
Justice Black leaned incredibly heavily on the presumed reliability of the military's assessment.
His entire justification for bypassing strict scrutiny was that the court couldn't reject the military's judgment as unfounded. If the Department of Justice, the government's own lawyers, had explicitly told the court, actually, Your Honors, the judgment is unfounded, it would have destroyed the central load-bearing pillar of Black's argument.
It would have exposed the lie in broad daylight. They wouldn't have been able to hide behind military necessity.
It would have forced the court to acknowledge that they were upholding the internment based on naked racism, not strategic necessity.
Precisely. And maybe, just maybe, that glaring exposure would have been enough to swing the vote. Justice William O. Douglas, for example, agonized over his vote with the majority.
If he had seen proof of the lie, he might have joined the dissenters. But because the evidence was suppressed, the lie became the law. And it stayed the law, buried in the dark, for decades.
Until the early 1980s. Fast forward almost 40 years. How does this buried truth, this suppressed intelligence, finally come to light? Because governments don't usually volunteer their darkest secrets.
No, they don't. It is a story of incredible, tedious, brilliant persistence by researchers. In the early 1980s, a legal historian and lawyer named Peter Irons and a researcher named Eiko Hertzog-Yoshinaga were independently digging into the federal archives.
Paint the picture for us. How are they finding this?
I picture them in massive, dimly lit, climate-controlled warehouses of the National Archives, surrounded by thousands upon thousands of dusty, forgotten cardboard boxes containing World War II-era memos, telegrams, and communications.
Just a sea of paper.
Eiko Hertzog-Yoshinaga, who had herself been incarcerated in the camps as a young woman, was working for the Commission on Wartime Relocation and Internment of Civilians. She spent years meticulously combing through the records.
It's exhausting work. It's looking for a needle in a haystack of bureaucratic red tape.
But they found the needle. They found the smoking guns. They found the original drafts of the DOJ briefs. They found the frantic, angry memos from Ennis and Burling pleading with Fahey to disclose the intelligence.
They found the suppressed Rengel report.
And Eiko Hertzog-Yoshinaga actually found the Stop the Presses document, didn't she? The original draft of General DeWitt's report.
Yes, she found the only surviving copy of the original draft of DeWitt's final report.
In that original draft, DeWitt explicitly stated that it was impossible to ever determine the loyalty of Japanese Americans, regardless of how much time passed.
Proving that his motivation was deeply rooted in racist ideology, not just a temporary wartime emergency. The War Department had tried to destroy all copies of that draft and forced DeWitt to soften his language before it went to the Supreme Court. But she found the one copy they missed.
So Irons and Hertzog-Yoshinaga have the undeniable documentary proof that the government lied to the Supreme Court. Finding that evidence fundamentally changes everything.
It takes this ruling, which had always been viewed by legal scholars as an ugly, embarrassing stain on the court's record, a failure of judicial nerve, and transforms it into an active, malicious scandal.
It radically shifted the historical and legal narrative. The long-term perception of Korematsu was no longer just about a debate over judicial deference. It was now a documented, undeniable case of prosecutorial fraud.
So, with the truth finally out in the open, the nation had to grapple with this. You have a Supreme Court precedent built on a deliberate lie. You have 120,000 lives disrupted, ruined, traumatized.
How do you fix a historical injustice of that staggering magnitude? And what happens to that loaded weapon Justice Jackson warned about?
That brings us to the long reckoning. With Peter Irons and Eiko Hertzog-Yoshinaga's archival discoveries in hand, a massive legal and political effort began to try and right the wrong, starting with Fred Korematsu himself.
Because legally, in the early 1980s, Fred Korematsu was still a convicted criminal. That federal conviction from 1942 was still sitting on his record.
Yes, so in 1983, Peter Irons and a team of brilliant pro bono civil rights lawyers took this newly uncovered evidence and filed a very rare legal maneuver in federal court called a writ of coram nobis.
Let's explain coram nobis for our listeners, because it's not something you hear about on standard legal procedurals. What exactly is the burden of proof here?
Well, it's an ancient legal writ. It's essentially a petition to a court asking it to correct a judgment that was based on a fundamental error of fact. But it's not just saying, hey, we found some new evidence, let's have a retrial.
The burden is incredibly high. You have to prove that the error was not known at the time of the original trial, and that the error was so profound, like prosecutorial fraud, that it resulted in a complete and total miscarriage of justice.
It's a way of saying the entire foundation of the original court process was fundamentally corrupted by a lie.
So this legal team goes to federal district court in San Francisco to Judge Marilyn Hall Patel. And they lay it all out. They present the suppressed intelligence reports from the ONI and FBI.
They present the buried DOJ memos from Ennis and Burling. They present the proof of the lie.
And Judge Patel's ruling in 1983 was a watershed moment in American legal history. On November 10th, 1983, she officially vacated Fred Korematsu's conviction.
She wiped it away completely.
She did. And her written opinion was scathing. She didn't just quietly dismiss the case on a technicality. She explicitly cited manifest injustice and formally legally documented the government misconduct.
She stated clearly on the record that the government had deliberately omitted relevant information and provided misleading information to the Supreme Court of the United States.
That has to be a massive vindication for Fred Korematsu, who spent 40 years living with a criminal record for just wanting to stay in his hometown.
But it's also a deeply bittersweet victory for constitutional law, isn't it? Because Judge Patel is a district court judge. She has the power to vacate Fred's specific criminal conviction, but she does not have the power to overturn a Supreme Court precedent.
The 1944 Korematsu ruling, Justice Black's opinion, Justice Jackson's loaded weapon, was still technically active law on the books.
Exactly. The Supreme Court's judgment was never formally reversed by the court at that time, but its factual and moral foundation had been completely obliterated in the public eye.
This judicial reckoning at the district court level added immense momentum to a parallel political movement for redress that Japanese American activists have been fighting for years.
The push for an official government apology.
Yes. There had been a federal commission investigating the internment in the early 80s. With the archival evidence now public and the Korematsu's victories for Korematsu and other resistors like Gordon Hirabayashi and Minoru Yasui, Congress was finally forced to act.
In 1988, President Ronald Reagan signed the Civil Liberties Act.
And the text of this act is incredible when you contrast it with the original 1944 judicial abdication. Think about the stark difference.
In 1944, the Supreme Court looked at the internment and said, "We defer to military necessity." But in 1988, the legislative branch, the United States Congress, formally concluded that the mass incarceration was absolutely not driven by military necessity.
What did Congress explicitly say it rested on?
The Civil Liberties Act explicitly stated that the internment was motivated by race prejudice, war hysteria, and a failure of political leadership.
Race prejudice, war hysteria, and a failure of political leadership. They admitted exactly what Justice Frank Murphy had written in his lonely dissent 44 years earlier.
It was a profound institutional admission of guilt by the United States government. The act provided a formal presidential apology and offered $20,000 in redress to every surviving Japanese American who had been incarcerated.
It's a powerful moment of accountability. It shows that the system can occasionally self-correct, even if it takes almost half a century.
But as we move into the modern era, that lingering shadow of Justice Jackson's warning remains. The political branches apologized. A lower court vacated a conviction. But what about the Supreme Court itself? What about the loaded weapon?
To answer that, we have to fast forward to a very recent and highly contentious moment in Supreme Court history, the year 2018.
2018. The case is Trump v. Hawaii.
Yes, this was the landmark case regarding the presidential proclamation that restricted travel and immigration from several predominantly Muslim countries. The policy was widely referred to in the media and by its critics as the travel ban.
And during the oral arguments at the Supreme Court, and heavily in the dissenting opinions of that case, the ghost of Korematsu was summoned explicitly.
Critics of the policy argued that the government was once again using a broad, vague claim of national security to justify a sweeping policy driven by religious or racial animus, just like General DeWitt did in 1944.
The parallels being drawn by civil rights advocates were intense and pointed. They argued that the court was facing the exact same fundamental test it faced in 1944. Would the justices blindly defer to the executive's claim of a security threat, or would they demand rigorous proof that the policy wasn't just disguised prejudice?
So Chief Justice John Roberts writes the majority opinion in Trump v. Hawaii. It's a 5-4 decision upholding the travel ban.
The majority rules that the president has broad statutory authority to suspend the entry of aliens, and they heavily defer to the executive branch's national security justifications.
But in the middle of this opinion upholding the ban, Chief Justice Roberts takes a highly unusual detour. He directly addresses the comparisons to Korematsu that the dissenters raise.
And he uses the opportunity to formally, on behalf of the Supreme Court, repudiate the 1944 decision.
What exactly did he say? How did he word the repudiation?
He wrote that Korematsu was gravely wrong the day it was decided. He stated that it has been overruled in the court of history, and incredibly significantly, he quoted Justice Robert Jackson's famous dissent.
Roberts wrote that the Korematsu decision has no place in law under the Constitution.
So what does this all mean? Let's analyze this. Chief Justice Roberts explicitly says Korematsu was wrong. He officially quotes the loaded weapon dissent. On the surface, if you just read those sentences, it sounds like a massive, long-awaited victory.
It sounds like the Supreme Court finally officially killed the monster. The loaded weapon is unloaded, the drawer is empty.
Well, This is where we reach the most contested, open question in modern constitutional law, because many legal scholars and the dissenting justices in Trump v. Hawaii, specifically Justice Sonia Sotomayor, argue that the weapon was absolutely not unloaded.
In fact, they argue the exact opposite.
Explain Sotomayor's argument. Because if the Chief Justice just put in writing that it has no place in law, how can she say the weapon is still loaded?
Because of the context in which he said it. Justice Sotomayor, in her blistering dissent, argued that Chief Justice Roberts only brought up Korematsu to throw it away as a rhetorical distraction, while simultaneously applying the exact same flawed deferential logic to uphold the modern travel ban.
She argued he was pulling a judicial bait and switch.
Essentially, yes. Sotomayor argued that the majority in 2018, just like Justice Glack's majority in 1944, was blindly deferring to the executive branch's claim of a national security threat without rigorously examining the underlying evidence of animus.
She pointed to the numerous public statements made by the president as evidence of religious animus, arguing that the court was ignoring the obvious reality, just as the 1944 court ignored the obvious racism of General DeWitt.
She wrote that by repudiating Korematsu in name, but applying its deferential methodology in practice, the court merely replaced one gravely wrong decision with another.
She's basically saying, you can't claim to disarm the loaded weapon while you are actively pointing a newly painted version of it at someone else.
That is the crux of the modern debate. Does invoking a discredited, toxic precedent just to say, we aren't doing that, truly bury the ghost of Korematsu? Or, by deferring to the executive's modern national security claims without demanding rigorous proof, does the court quietly reaffirm the exact same dangerous deference at its core?
It's terrifying, because if Sotomayor and the constitutional scholars who agree with her are right, then Jackson's warning isn't just relevant history, it is a description of the current reality. The weapon just got upgraded.
It forces us to ask an incredibly difficult question about the balance of powers. In a genuine modern emergency, how much should courts defer to the executive branch or the military?
There is a legitimate, undeniable need for the executive to act swiftly to protect the nation. The courts move slowly. Crises move fast.
Right. No one is arguing that the president needs to file a motion and get a federal judge's permission to scramble jets if the country is actively under attack.
Exactly. The hard question is not whether deference is ever appropriate. It often is. The hard question is whether a court that absolutely refuses to examine the factual basis for a government claim, a court that just looks at the word security, throws its hands up, and stops asking questions, is actually functioning as a court at all.
Or is it just a ceremonial rubber stamp designed to make executive power look legal?
And that brings us full circle to the sheer, sweeping magnitude of the Korematsu story. It's a massive, sprawling journey we've taken today. We started with the human tragedy in 1942, 120,000 American lives upended, citizens forced to abandon their homes and live in horse stalls and tar paper barracks in the desert, driven by racism and economic greed, masked as military strategy.
We examined the tragic abdication by the Supreme Court, watching brilliant legal minds like Justice Hugo Black contort themselves to justify the unjustifiable, inventing standards like rigid scrutiny only to immediately ignore them.
We looked at the three lone voices of reason in the dissents. Justice Roberts exposing the mechanical trap of the military orders, Justice Murphy courageously calling out the legalization of racism and comparing American policies to fascist enemies, and Justice Jackson prophesying the loaded weapon of precedent.
We saw how the archival revelations of the 1980s, the painstaking work of researchers finding suppressed ONI and FBI reports, proved that those dissents were right all along. We saw how the government actively suppressed the truth to win a court case, fundamentally shifting the legacy of the ruling from a story of judicial weakness to a story of government fraud.
We discussed the reckoning, Judge Patel vacating Fred Korematsu's conviction via coram nobis, and the 1988 Civil Liberties Act finally providing a formal apology for the failure of political leadership. And we trace that legacy all the way to a modern courtroom in 2018, where the ghost of Korematsu still haunts the tension between national security and civil liberties today.
But ultimately, through all the legal theory and historical analysis, we must never lose sight of the fact that this deep dive is not just a story about abstract constitutional theory. It is a story about Fred Korematsu. It is a story about real families, American citizens, whose lives were destroyed because the institutions designed to protect them, the Justice Department, the military, and the courts, simply saluted instead of asking hard questions.
And that leaves us with a chilling thought for you, the listener, to mull over long after this episode ends. History unequivocally proved that the military and the executive branch lied to the Supreme Court in 1944. They hid the exculpatory evidence. Yet, the legal architecture today still heavily defers to the executive branch the moment they invoke the magic words national security or emergency. The next time the government claims an urgent, top-secret, classified threat requires stripping a specific group of people of their fundamental rights. Who will be the ones searching the archives decades later to see if it was actually true? And by the time they find the truth hidden in those dusty boxes, will it be too late?